behalf of the appellant, Mr. Robert Denton. Judge Greenholtz and Mr. Clerk, may I reserve 4 minutes for rebuttal, please?
Of course you may.
Thank you, Your Honors. Mr. Denton is here on appeal from convictions out of Sullivan County stemming from a 2015 three 2015 killings. The state's theory at trial was that Mr. Denton walked into the kitchen of his grandparents' home with a rifle, killed his mother, his grandmother, and his mother's husband, his stepfather. In the kitchen, there were 6 children, one of whom CP was 8 at the time, and testified at trial that Mr. Denton was the person, her half-brother, who she saw come into the kitchen, kill her mother, grandmother, and stepfather. Mr. Denton also testified at trial, and the jury convicted Mr. Denton on 3 counts of first-degree premeditated murder and then some aggravated assaults and reckless endangerment against the children who were in the kitchen at the time. And against that proof, we have raised 3 issues on appeal. One is the issue of the aggravated assault and whether or not essentially there was sufficient evidence to convict based on a young girl, S.H., who was in the kitchen at the time. And second, a dying declaration that is actually not a hearsay analysis, more so of an abuse of discretion analysis of whether or not the trial court erred in finding whether Mr. Milhorn was competent witness for the dying declaration utterance. And then another on some photographs. Unless the court has specific issues, I'm happy to answer them on the other 2 issues, but I'd like to speak mostly to the dying declaration. The attorney at trial was the 3rd appointed attorney, to my knowledge, and I know there's been some discussion about preservation of the issues in terms of whether or not Mr. Denton is entitled to plenary review. We'd argue that he is. The issue on the dying declaration is one that I have not encountered before, but an interesting one. The counsel did not, let me back up. Mr. Denton was found outside of his home, paralyzed, having been shot twice, one paralyzing him after severing his spinal cord, and the other one that went through his colon and abdominal cavity. And at 2 different times, he told first his father-in-law, Mr. Rose, Mr. Denton's grandfather, that Mr. Denton had shot him. And he also told the same thing to an EMT. Trial counsel did not object to the fact that this was a dying declaration. What instead trial counsel did was object to whether or not Mr. Milhorn was a competent witness under Tennessee Rule of Evidence 602. The state and I have gone a little bit back and forth, and I'm happy to answer any questions on that about what kind of proof is necessary for the trial court to determine whether or not that issue then goes to the jury. And like again, I said, this is not this is an abuse of discretion decision by this trial court, because it would have been whether or not the trial court found that Mr. Milhorn had the opportunity to observe or have personal knowledge of the individual who shot him. I think the state, and I'm sure the state will correct me if I've stated it incorrectly. But I think the state takes the approach that if there are 2 different competing stories of whether or not Mr. Milhorn would have had the opportunity to observe the person who shot him, that then becomes immediately a question for the jury and is one of weight rather than admissibility. It crosses that threshold. And I think we would argue in response a little bit differently in that the trial court also has the discretion, because it is in place in the trial court, to make a credibility determination. So it's not just whether or not there are 2 competing stories so that the trial court has to resolve any credibility issues, but the trial court in and of itself can make a credibility determination by the 2 competing utterances or the 2 competing versions of whether or not he would have been able to view the person who shot him. The testimony that we would argue would tend to show that Mr. Milhorn did not have an opportunity to see who it was that shot him comes from CP and from the testimony of Dr. Eugene, and I hope I'm pronouncing this correct, Scheuerman, Scheuerman. First, Ms. CP testified that when she saw Mr. Denton come into the kitchen, it was only her grandmother and 5 other brothers and sisters and her friend who were in the kitchen. There's no testimony at trial that ever places Mr. Denton in the kitchen such that he would have seen who came in to shoot him. And the second comes from Dr. Shireman, who says that the shots, number one, were fired with the barrel of, I think it was a 30-06 M1 Garand rifle. They were fired when he had his back to the shooter. So there would not have purportedly been an opportunity for him to see who the person was. And also from Mr. Rose, his father-in-law, and Mr. Denton's grandfather, who essentially found him where Dr. Shireman said he probably would have dropped because the shot that fractured his spinal cord would have caused almost immediate paralysis.
Can I ask you on
Absolutely.
that? If I recall right, correct me if I'm wrong, please, he not only identified the shooter, but he identified the gun, that it was a long gun. So if he was able to see the gun, and he was paralyzed after the shooting, doesn't that, the context of that indicate that he saw the shooter if he saw the gun?
It could. I would argue, and it's going to be one of those things where the gun may have been able to be seen. Seeing a firearm is going to be a distinction that, again, the trial court's going to have to make, whether or not someone in that circumstance is going to be able to see and identify the person and not just the firearm. Okay. So that would be, and that goes again to what we would argue, that the trial court does have to make a credibility, has the opportunity to make a credibility determination about who is giving the source of the information that is the two competing.
So the issue is phrased, I think, as a competency issue.
Yes.
That the witness was not able to see directly, I suppose, with his own senses, who was doing the firing. What if it's an opinion issue? So what if it's the difference between defendant shot me and I think defendant shot me, and that the opinion is being formed rationally so based upon the other circumstances that the victim could perceive, and that opinion would be helpful to the trier of fact to resolve an issue of fact and determination. So could there be a competency issue here with the ability to form an opinion, meaning that the defendant was the only one who had a gun at the time, the defendant was the only one in the kitchen firing off rounds at the time, and that evidence is supported by other witnesses? And so couldn't it be a situation where the victim is offering an opinion rationally based upon the victim's perception and such that it would be helpful to the trier of fact?
I think the response will be twofold, and I'll have to refer you to the specific cases. I know they're in my brief.
Okay.
But our courts have stated it can't, I think a court referencing like a lay opinion.
Mm-hmm. That's right under 701.
Yep. I think the court has cautioned against a lay opinion in terms of making the competency basis for admission for a hearsay declaration such as this. And I know it's specific. I can bring it up on rebuttal.
Sure, okay.
But one thing our courts have specified is there has to be more than just it appears that they had the opportunity to. And I think that gets a little bit to your question. Okay. So the circumstances certainly would suggest if he shot, if it's at that close of a range, that it appears that somebody would have the opportunity to see somebody who's shooting them at that close range, and purportedly someone who, if it's your stepson, you might be more familiar with. But the case law has said there's got to be a little bit more than just a mere suspicion who might have shot you.
Well, it is a little more than just a mere suspicion, right? Because, I mean, the facts of the case are such that no one else had the opportunity to be firing rounds, right?
Perhaps. I know I think if you're getting to, there was testimony that Mr. Rose had firearms in the home, which I think was the defense theory at the time. Not necessarily, he had a pistol, though, to your point, Judge Sword, that it was not a long gun. The ones that they found in his home were inoperable. But I think there was testimony that there was a pistol. So there would have purportedly been someone who may have had the ability to use a firearm, not necessarily along a rifle, or certainly a .30 caliber chambered rifle. But I think in terms of the label, it's got to be something that is more than a mere suspicion, that it's got to be something that shows that they have something that leads them to believe that they formed that opinion. Because I think the underlying basis for including for the hearsay exception is that like a statement against interest or a dying declaration, you have no incentive to fabricate it, but you do have to have some sort of sense of your surroundings in order to make that statement reliable. I think one of the examples that we included was a woman who shouted out, my car, he stole my car." Well, it would have been, I think the trial court found that, or on appeal, found that it would be a little bit kind of fuzzy in that, was she in fact saying he stole my car, or was she just remarking that he stole my car? So I think that would be the distinction that we would probably draw on the dying declaration.
If there is error, is there harmless error? Because you have other witnesses who were in the kitchen at the same time, and they are affirmatively identifying the defendant as the one who is shooting the rifle.
We do argue in our brief that it was harmless. And I think the path that we took on that was that those, and I do need to point out the trial counsel only objected to the dying declaration that was testified to by EMT Amy Brown. Mr. Rose testified, and there was no objection that that dying declaration came in. So under that, there would be some significant question of whether or not this was indeed harmless. We have argued, and I believe that the admission of this testimony cast the ultimate, I think the testimony from CP was certainly, as I would say in my vernacular, stronger than train smoke. She was in the kitchen at the time. It was her half-brother. But it would have, in a determination of a credibility battle, which was ultimately between Mr. Denton and CP, and the jury chose CP, is that was one more maybe tick box in the favorability toward having CP's testimony accredited over her half-brothers.
If I can take you off of your issue and ask
Sure.
you about the first issue that you raised about the aggravated assault. How do you distinguish Emerson? Emerson is a case that the court decided, I think maybe from its August docket in Jackson. The facts of the case, as I recall, were the defendant is shooting the victim in a bedroom about 10 feet away, albeit in another room. There is an adult and maybe one or two children. The jury convicts the defendant of aggravated assault against either the adult victim and maybe also the children, against an argument that the children themselves did not perceive, or they did not testify, and so therefore there was not proof in the record from the children that they were placed in fear from the gunshots. I believe that Emerson held that a reasonable person in those circumstances, 10 feet away, that a jury could infer from those circumstances that you could have a reasonable fear of imminent bodily injury at that point. If that's the correct characterization of Emerson's holding, how do you distinguish Emerson?
That is correct. Emerson is, from what you're describing, Your Honor, that is in complete simpatico with the case law that the state and I have pointed out. You do not need a witness. A victim does not need to testify, sure, and in order for a jury to convict, that they can perceive from the rational circumstances, as indicted here, that the young girl would have reasonably been in fear.
So SH, how is the evidence insufficient then to establish aggravated assault against SH?
So I think this argument is at its core a sufficiency argument that abuts to some more interesting principles that we already have. Like, you can have inconsistent verdicts, right, which would be here we have a conviction for reckless aggravated assault, which is a lesser included of what Mr. Denton was actually charged with, which was aggravated assault for the injury that he caused to CP, and then a reckless endangerment against the other children. Right. So those are inconsistent verdicts. And then you also have the principle that circumstantial evidence, even in the absence of a victim's testimony, is enough to sustain a conviction. I think ultimately it comes down to sufficiency, that if a jury finds that Mr. Denton possessed a reckless mens rea with regard to CP, who was actually injured, and the rest of the children who were recklessly endangered by his actions, that there is nothing in the record, even circumstantial evidence, to support a finding that he possessed any different mens rea other than reckless with regard to SH. So I think at its core it is a sufficiency argument and does does keep in line with this court's finding that circumstantial evidence is fine. The victim need not be there in order to testify in order for
Right,
conviction.
but the
to
mens rea,
result.
I guess, would have to be intentional or knowing.
Yes.
The jury could make a finding, though, that the reckless mens rea for reckless endangerment was satisfied, right, if the jury also concluded that the defendant acted knowingly.
Mm-hmm.
Okay, fair enough.
Yep. That's correct. Your Honor.
Okay.
And I have nothing further. If the court has any questions, I'll cede the rest of my time and allow the state to continue.
Thank you very much. Thank you. General, good afternoon to you.
Jim Gaylord on behalf of the state. So the dying declaration issue, I think, is nominally a case of first impression before the court. I don't think the court's encountered a personal knowledge challenge to a dying declaration before. We agree with the defendant that that requirement does apply, and the reason for that is this court has applied it to an excited utterance in State v. Land, a published decision, and at arriving at that holding, the court cited dying declaration cases. So the question is how that requirement is applied. And the rule that we're asking you here for today is that when the dying declarant identifies his assailant, we presume that he has sufficient opportunity to perceive that, to perceive the event. And the reason for that is the statement itself lays the foundation. If he says that Seth shot me, we presume that he saw Seth. Now that presumption can be overcome, but it can only become overcome by clear evidence that the witness did not, in fact, have that opportunity.
Do you have that here where the victim is shot in the back?
Well, I mean, one, they're in the same room. Two, yes, he's paralyzed from the waist down, but that doesn't mean, one, that he wasn't chased before he was shot, or even after a shot that he simply couldn't turn his head.
Well, what I heard you say is that initially we presume that, and so there's no further proof that's required, but that it's a rebuttable presumption, and so if there is proof rebutting the presumption, then we go back to the default rule then of proof of competency, right?
That's correct.
And so if we initially presumed it, there is proof rebutting the presumption, it seems, in the record. And so, but what I hear you arguing now is that maybe we should just make inferences.
Well, what we're saying is that the presumption is rebuttable, but it has to be rebutted by clear proof that if we look at all of the proof, it's clear that this witness could not see what was going on. There's an off-cited case, I think it's out of Pennsylvania, that involved a bomb. And after the bomb went off, the dying declarant said Joe did it. And the problem with that is that the victim wasn't there when the bomb was set. So the court says that doesn't come in because you're merely speculating about the identity of the murderer. So that's the character of the evidence that can rebut the presumption, is when it's just clear that the declarant did not have the opportunity to.
I guess I don't understand necessarily the kind of the threshold burden that you're arguing should apply to the rebuttal of the presumption. You keep saying clear proof. Is that by a preponderance of the evidence? Something
I
less than that?
think it would probably be clear and convincing.
That high?
That high.
From where do we get that rule?
Because otherwise it's simply a jury question. If it's like maybe he saw it, maybe he didn't, then the jury gets to decide the credibility of the testimony.
Why isn't just the rule you need to have competence on the front end and we have no presumptions?
Two reasons, I would say. One, we presume the witnesses are competent. And second, it would also inhere in the nature of the dying declaration that under those circumstances, people aren't likely to make things up. So if there's a credibility dispute, that credibility dispute goes to the jury. Put another way, it goes to weight, not admissibility.
Do you agree with your friend on the other side that we should not view this as an opinion?
Yeah, I think if it's an opinion, if it's speculation, the trial judge has discretion to keep it out, certainly. And this is the rule, the trial...
Well, opinions wouldn't be speculation. I mean, it would be rationally based upon the perception of the witness.
Well, that's correct. I shouldn't be equating opinion with speculation, but I don't think opinion testimony is consistent with a dying declaration.
Okay.
He has to actually see who did it, or actually sense who did it. And this is the rule that the trial court followed in this case. He said, if you say Seth shot me, that's good enough. I don't think he has to say, I saw Seth shot me. But the fact of the matter is there's quite a bit more evidence here, and I would initially call attention to what Judge Sword said. We had a previous dying declaration that was not objected to, and in that declaration, Mr. Milhorn was asked what kind of gun was used, and he said a long gun. Well, if he saw the murder weapon, how did he not see the person who was employing it? It's very difficult to arrive at that conclusion. And then in this dying declaration, he said that he was protecting his family. Well, it follows from that he was able to perceive that there was a threat to the family. And this is a witness who was conscious and talking for quite a while after he was shot. And in the end, he was able to identify Seth, his stepson, whom he knows. And if we look at all four of those factors, even if the court weren't to adopt the test that I'm proposing, it's still clear that there is adequate foundation for this witness's testimony. I'm probably not going to address the aggravated assault unless there are questions about it. Okay. We would ask this court to affirm. Thank you.
All right, General, thank you very much. Ms. Jones, 4 minutes.
Your Honor, I only want to do two things, and the first is just to direct your honors to the portion of my brief. It's on page 77 where it says, in a quote, similar, and this is me quoting myself, similarly, a lay opinion by the deceased regarding the identity of a defendant, quoting a case, should not be allowed simply because it is in the form of dying declaration, though it must not be also unduly restricted when reasonably based. And that's from State versus Lewis, 235 Southwest 3D 136 at page 150. And the second thing is to thank my friend on the other side who picked up this case, which has a huge record very far into its path, and did an excellent job responding. It was a delight to respond to. And that's it. And for all the reasons contained in our brief, we would ask this court reverse for new trial. Thank you.
Thank you both very much. We appreciate, once again, you all making arrangements to be with us here today. Thank you both very much for your advocacy, both here today and in the briefs. Thank you. Would you call the next case, please?